be able to catch up. So first of all, let me introduce myself. My name is Jackie Kamau. I'm a judge of the High Court of Kenya, working at Milimani Law Court Civil Division. Presently, I'm the president of the Kenya Magistrates and Judges Association. This is an association that is composed of judges and magistrates. And our job is to dispense justice, but we also have other objectives. Some of them are to ensure that our members also get trainings. So we welcome all our members to this very, very important webinar. First of all, I want to acknowledge Justice Omondi. She never misses. And the other magistrates, all the other magistrates, because I might not mention everybody because of interest of time. She will represent all the persons in the judiciary. This is a three-part webinar, which is done with the collaboration of Kenya Magistrates and Judges Association and Kenya Cybersecurity and Forensics Association. That is KCSFA. The chair of KCSFA is Mr. Kenny Zagira, and he will give us his remarks at the end of this webinar. He's going to give the vote of thanks and also give his closing remarks. Now, as you are registering, you noted that there was a place where you were asked to post your questions. Of course, you could post your questions to kenise@kcsfa.co.ke, but I think for expediency purposes, for purposes of this webinar, you could also send your questions to the chat, and then I will be able to pick them. After about 30 minutes, we will be able to have a break of like 10 minutes when we are going to have the panelist answer some of the questions that will be burning at the point. But any person who will find that the question has not been answered by the end of the presentation, then we'll ask that you forward the questions to kenise@kcsfa.co.ke and they'll be answered. I will also be asking that any participant, please mute your audios and videos so that we can give our presenter, Lawrence Dinga, the space to present to us. As you've heard, this is a session which is going to be a three-part series of this very, very important topic. I don't know whether you have all seen the flyer, because I believe that you must have seen the flyer for you to be able to come and join us to date. So the webinar is a three-part webinar, which is part one is today, which is the digital evidence. Part two is digital forensics process. This will be on the 1st of October, 2020. The presenter has asked that we mention that it's going to be a very technical part. So it's important that when you follow up with today's, because it's going to be an introduction, the part two, which will be on the 1st of October, 2020, will be a little bit more technical. So it's important that at least you're able to follow them up. And part three will be the expert witness in court. That will be on the 15th of October, 2020. So this is a three-part because obviously, like he will let us know that you can also do this course in India, which is a very compact, but he's going to try and condense all this information within a very, very few hours. But I know because he's very, very competent, he's going to be able to deliver whatever we want so that it's an appetizer, so that when we have other courses which are more detailed, then we can have the same. Maybe just to mention a little bit, you can see his CV is that he holds an MSc in Forensic Computing and Security from the University of Derby in England, LLM in ICT Law from the Open University of Tanzania, and Diploma in Law from the Kenya School of Law. So he's got a legal background. So that's the reason why he actually can be able to understand where we're coming from. And he's also a certified information systems security professional. He has extensive IT consultancy and cyber capacity building experience. So I think you can read and you see how well learned he is in this field. We say that we are judges or we are learned friends, but there are some people who are more learned than others. So Mr. Dinga, we hope that you're going to share this information, because as a teacher, your responsibility is to share with us. And by the time when we finish, then we probably will be able to say that you are a good teacher. We managed to get something out of it. So without much further ado, let me welcome you to speak for the next half hour. We will still give you your 1 hour, but we'll break within 10 minutes, after 10 minutes for the questions. So welcome, Mr. Lawrence Dinga.
Thank you very much, Justice Kamau. I think you can hear me, all of you can hear me.
Yes, we can hear you clearly.
Okay, thank you so much for the introduction. As Justice Kamau has introduced me, I just need to start straight away. Now, as Justice Kamau said, these are three-part series, and today we are going to look at the digital evidence. Now, in this series, in this session, what we are going to look at, we are going to provide the definition of digital evidence. Then we look at the role of digital evidence in legal proceedings. Then we are also going to look at challenging aspects of digital evidence, plus looking at the types of digital data that you may encounter as a forensic investigator. Then we look at guidelines and principles of digital evidence. Here, what we are talking about when we talk about guidelines and principles of digital evidence, what I mean is that cybercrime is a transnational activity. You might find that sometimes the criminal is in Kenya, the crime has been done in Uganda, and the evidence is actually somewhere in Tanzania. Now, when you want to prosecute this person, how do you get this digital evidence? Can the people, those people who are having the evidence, let's say, for example, Tanzania, can they process that evidence and then send it straight away to Kenya, and then it is admitted in the court of law? So those are the guidelines that we are going to look at. Then we're also going to discuss the issues of admissibility of digital evidence in terms of its authenticity, reliability, relevance, credibility, and integrity. And because of time, I don't think we can do all these session objectives, because we could have looked at the principles of best practice relating to handling and seizure of digital evidence. And then we also look at the challenges offered by dead box, live forensics, and internet sources of evidence, because evidence is found everywhere. Evidence can be found in computers, evidence can be found in mobile phones, or evidence can also be found on the internet. How do you collect that evidence? Then the last thing this session is talking about is identifying the challenges of obtaining evidence from another jurisdiction. How do you go about this if there is no, for example, there's no treaty between the two countries? How can you be able to get evidence from foreign jurisdiction? However, as I've said, we cannot be able to do all this within 1 hour. So I'm going to try to talk about the points number 1 and point number 2, and then the rest we can do as much as later on as we go through this three-part series. Now, first of all, well, let's look at the definition of evidence. What is digital evidence? Now, basically, there's no internationally accepted definition of digital evidence. However, in many jurisdictions, or in all jurisdictions, there are regulations containing conditions that that somehow define what digital evidence is within that particular jurisdiction. For example, in Kenya, we have the evidence law, or the Evidence Act, which is the principal source of law when it comes to digital evidence. Now, in this act, we have section 65, subsection 8, which talks about computer printouts. Then we have section 78A, which is talking about electronic messages such as WhatsApp and SMS. Then we also have section 106B, which is talking about electronic records. Now, this act also stipulates the conditions of admissibility of such evidence. So that is that is what I can say, that we do not have internationally accepted definition of the word digital evidence. However, when we look at the dictionary, digital evidence refers to any information that is generated, stored, transmitted in digital form, and that may be later be needed to prove or disprove a fact in legal proceedings. Now, where do we find this evidence? We find this evidence in digital devices such as computers, such as computer networks, mobile phone, digital cameras, storage devices, digital storage devices, as well as the internet. But these are devices. So when we have these devices, where do you exactly find that digital evidence? You'll find that digital evidence will be in graphic files, they will be in audio files, they will be in emails, server logs, and the rest. So these are where you can, when you get these apparatus, then those are the files that you can use to generate this digital evidence. Now, what is the role of digital evidence in legal proceedings? Now, if we are looking at digital evidence, somebody has brought the digital evidence in court, then it must be able to establish a credible link between the attacker, the victim, and the crime scene. So if you cannot be able to prove to the court that there is a link between the attacker, the victim, and the crime scene, I think you as judges and magistrates, you'll always throw this thing out of the window. So this is something that is illustrated by what we call Locard principle, exchange principle. The Locard exchange principle states that anyone or anything entering a crime scene takes something of a crime scene with them and leaves something of themselves behind when they leave. Now, this Locard exchange principle concept was developed by Dr. Edmund Locard, who lived between 1877 and 1966. And Dr. Locard speculated that every time you make a contact with a person or a place or anything, it results in exchange of physical material. Now, he believed that no matter where a criminal goes or what a criminal does, by coming into contact with things, a criminal will leave all sorts of evidence, such as the DNA, footprints, skin cells, blood, and things like that. And at the same time, the criminal will be able to take something away from the crime scene. Now, this also translates very well within the computer area. So if we look at the computer, everything you do on a computer or a network leaves traces, from the deleted files to unregistered entries to the internet history. So whenever you make a contact with the computer, whenever you do anything in a computer, it will leave some traces. Things like email. Email has got email headers and messaging logs that can tell somebody how that email has traversed the internet until it reaches the destination. We have things like server logs, which also tells you which system connected to that server, what that person was doing in that server. So these are evidence that can be associated with somebody who actually entered into use that computer. Now, when you're looking at digital evidence, there are some challenges that we will expect. First of all, digital evidence is invisible to untrained eyes. You need a specialist with special tools to actually get the digital evidence from the digital devices. So the other thing is that the digital evidence is volatile. Volatile in the sense that it can quickly disappear or be deleted or be overwritten. For instance, if when you put you switch on a computer, the computer switches on, and then we have the memory. Part of the memory called the random access memory, that is what carries what you are seeing on the screen. And when you switch off that computer, then what happens that the content that was in the RAM is actually lost. So sometimes it is lost just within the normal usual function of the device. For example, if you have a computer and the computer is low in memory, and you want to save a file, so what the computer will do, it will overwrite what is in the memory because the computer needs more memory. So it will transfer what is on the memory to somewhere else and write the new information in that part. Also, if you look at computer memory, it can also be corrupted through or lost through environmental factors such as excessive heat, humidity, or if you pass it through electromagnetic field. So it is volatile. If you compare digital evidence with other evidence, this evidence is very volatile and can be lost within a stroke of a key. The other aspect, challenging aspect of digital evidence is that it is fragile. It's fragile that it can be altered, it can be manipulated, it can be damaged easily just by a stroke of key. This can be done either intentionally or unintentionally. So, which means that when you are collecting the digital evidence, the process of collecting the digital evidence must therefore be methodical and systematic. That is what as you can see, the diagram I put below there is showing how you collect evidence or from hard disk. What is happening that you are acquiring evidence from that hard disk, and between the hard disk and where the evidence is going to reside, you have what we call the write blocker. So without that write blocker, which means that you can be able to write back to the hard disk, which will dilute, corrupt the evidence that is on the hard disk. So it is the process of collecting that evidence must therefore be very systematic. Now, the other thing about digital evidence, that it is circumstantial. The investigator needs to establish the link between the suspect device and the person who you think was operating it at that relevant time. Because you see, if you give me your phone, then I get evidence from the phone. Or you give me your computer and I do the investigation and I get evidence from that computer. What happens is that, yes, the evidence is there, but how will you establish that it is me who was sitting on that desk at that particular time? So digital evidence is circumstantial, and you need to prove that it is the person who was using that particular device at that relevant time. The other thing is also, it can be duplicated without degradation. So the information, the digital information can be copied indefinitely, and each copy will look the same as original. So what is important here is that because it is it can be copied without degradation, you need a specialist and you need special tools to make sure that when you are doing the investigation, you do the investigation in such a way that you are going to, the evidence that you are going to produce in court is relevant to that case. The other aspect is also the distributed storage. Now, the distributed storage, that is, we are talking about the availability of cloud and remote storages. Now, nowadays, there's a time I was doing a training to one of the revenue authority in Africa. And then their investigators were telling me that they went to do a raid somewhere. And when they went there, they found the computers were there, the monitors there, the CPUs there. But then these guys were telling them that our information, the data that you're looking for is not sitting here, it is sitting somewhere in the cloud. So you find that the cloud, the invention of cloud has actually given another connotation when it comes to digital forensic or digital evidence, because you can go there, you can go somewhere, you raid their premises, but the evidence is not found there. So the other, because Cloud computing is like what we used to have during early days of computing, the mainframe, whereby we had the mainframe computer and then we had the dumb terminal. The dumb terminals were dumb as their name because they were not doing any processing. But during any process, if you wanted your data to be processed, the data was keyed at the dumb terminal, but the processing was done at the mainframe. That is what the cloud computing has created right now, because you have your device, but you log on to a cloud somewhere, which sometimes you even don't know. For example, you log on to Yahoo, you log on to Gmail, you don't even know where the server is. So that has an effect when it comes to digital evidence, collecting that digital evidence. The other thing is also the rapid technical development. Now, when in IT, development is very fast. Technical development is continuing at a very fast pace. And this has a very big impact on digital evidence. For example, just to be a little bit technical, what we are using right now as in many servers or computers, they are coming with new hard disks called SSD hard disks, which is not magnetic like the older ones. So you find that this SSD presents some challenges when it comes to the digital the evidence. Now, the other thing is also the transborder. It is possible for a criminal to be in one country and the crime to happen in another country and the evidence to be held yet in another country. So that is very possible with cybercrime. You find that it crosses border. It does not respect the border. I'm here. I've attacked or hacked a computer in Tanzania, and then the evidence that we are looking at is actually somewhere in Europe. So it is transborder and does not respect the boundaries, and that makes it difficult for the cyber investigators to actually get this evidence. The other aspect also is proper procedures, techniques, and tools. As more traditional forensic disciplines, digital forensics requires special tools, special knowledge to undertake their investigation. It is different. It's a totally different kind of investigation, and you need special procedure and special techniques, because if you can go to court and it can be proved that you did not use the proper techniques, then that evidence will not actually be accepted in court. The court will cast doubt on that evidence, and it will be impossible to admit it. Then there also the admissibility aspect. The digital evidence must be obtained in compliance with existing legislation and best practice to ensure admissibility at trial. Yeah, just what I said is that when we are talking about the definition of digital evidence, we say that we do not have an internationally accepted definition, but each country has got some regulation or containing precepts that some way define what digital evidence is. And I gave you an example of the Evidence Act in Kenya. Now, the admissibility of that evidence depends on the legislation, existing legislation in that particular jurisdiction. Because you might, there are two things here. One, you might we might consider something as a crime in Kenya, but in Uganda it is not considered as a crime. So whatever evidence that you have here, it will be useless because it will not work in another jurisdiction. Now, let's look at, when you're talking about digital evidence, what kind of data are you talking about, or what kind of digital data or evidence you're talking about? Here, when you're talking about computer, we have what we call the volatile data. And I talked about the volatile data, that data which is in the memory, which is in the random access memory, And this data, when the computer or the device is switched off, the data is lost. So when as an investigator, by the way, this part of training on digital evidence is more of the investigating part of it, because you investigate and then you bring it to court. So when you go to a place where you have a computer and the computer is on, how do you collect that data? You have to look at, you might miss very important data. So you have to do your work according to volatility of the data. So you look at the data which is already in the memory, and if you can acquire that fast, then you look at the other types of data within that computer that are not actually erased when the computer is off. Now, there's also the non-volatile data. This is data that survives after the process which created has ended. It is permanent and stored in this. For example, when you are doing your Word document or a spreadsheet, you create your Word, and then when you are done, you say save as, and you give it a name. Now the process that created that file, which is the Word document. Now, even if you shut down the computer, that file is still saved within the computer. So it is stored in the hard disk. That is non-volatile data. Then we also have the transient data. Now, transient data is created within an application session. For example, when you are logging into your VPN, you put your credentials, you put your username, you put your password. Now, this information is only used within that session that you are connected to the internet, to the network, or whatever network you are. It does not, when you log out, that information is not stored. It's not stored in a database when you log out. So that is what we call the transient data. And this transient data, how you have to have a method of collecting it so that you can use it as evidence. Then we have what we call residual data, the data that is stored on a computer when a document is deleted. Now, I want to bring something which might not be very obvious to some people. Now, when you delete a file in a computer, that file is not actually deleted. That file is still residing in that computer. Now, the way computer stores a file is like if you have a book, and then in the book you have the table of contents. In the table of contents, you have each and every topic and a page where that particular topic is. So if I want introduction, I also see in the table of contents that the introduction is in page 3. So that is how computer stores information. Now, when you store you save a file, the computer assigns a specific place to store that file. Now, when that file is deleted, what happens is that the operating system will mark that place as deleted, but it's not actually deleted. It will just mark that place as deleted, so that when another file comes, then it knows that I can use that space that the other file was existing to store that file. So you'll find that in a computer environment, or in a network, or in a computer, you will have files that have been deleted, but when the computer, the operating system wanted to write to those spaces, either the file that is being written back to that place is smaller than the file that was originally there. So you find that the file that was originally there is only partly deleted, but the other part of it is still existing. So that is what we call the residual data. And that kind of data is so very important as an evidence when you are doing the investigation. Sometimes we call them slack spaces. Now, we also have what we call the metadata. Now, metadata is a record about a particular document, including the format and how it was created and saved and modified. For example, if I send you a photograph, a picture of myself. Now, when you look at that picture, there is information about that picture, which shows that, for example, if you took it with a camera which has got GPS enabled, then it will tell you it will tell you where that particular photo was taken. It will tell you the type of camera that was used to take that photo. It will tell you the particular application. So that data, which you don't see, is data about that particular that particular picture. That is what we call the metadata. So those are the types of data when, as an investigator, you are you are doing the investigation, you'll be able to find out how they are stored and where they reside. Now, I talked about the guidelines and principles. Now, when we are talking about cybercrime, we are saying that cybercrime is transnational, which means that the perpetrator may be brought to justice in one jurisdiction, while the digital evidence that is required to successfully prosecute the case may reside in another jurisdiction. Now, what these international guidelines and principles trying to do is harmonization. Is it possible that if the criminal is in Kenya and the digital evidence that we need to use to prosecute him is somewhere in Uganda, is it possible that those in Uganda, they can be able to process that data and straight away send it to us and use that data or digital evidence directly into the court, take it directly to court without having to process it again? So that is where these guidelines and principles come about. Now, the harmonization of computer forensic practice is not only paramount importance to investigation, but is also essential to international cooperation on cybercrime matters, because cybercrime is a real menace now, and it is something that we cannot close our eyes, because it is something that is real. Now, the standardization of digital forensic practices sorry, is key to ensuring that admissibility of digital evidence across jurisdictions. So that what they are trying to do is that, is it possible just we have evidence from this jurisdiction and we pack it, we bring it to this jurisdiction and just we use it without any questions. Now, this has been, some organizations have tried to do this. One of the organizations is called the International Organization on Computer Evidence. This was established in 1995 for the purpose of providing a forum for global law enforcement agencies for exchanging information regarding cybercrime investigation and other issues related to computer forensics. Now, IOCE develops international principle for the standardized recovery of computer-based evidence. And what they are looking at are the following attributes: consistency with all legal systems, which means that we can be able to exchange digital evidence from between jurisdictions. It's also looking at allowance for use of common language, and then it's also ability to cross international boundaries and ability to instill confidence in the integrity of evidence. Integrity of evidence is the most important thing when evidence is presented in court. So IOCE is one such organization that is in place that is trying to have digital evidence exchange between jurisdictions. The other one is called the ACPO guideline. ACPO means Association of Chief Police Officers, and this guideline is from the UK. Now, it is primarily written for the guidance of UK law enforcement personnel who may deal with digital evidence. Now, these are people who normally seize evidence and transport this evidence to the scene, from the scene to the laboratory, or they are investigators who plan and manage the identification and presentation of evidence, or perhaps people who recover and reproduce seized evidence and trained to carry out functions and have relevant training of the evidence, how evidence is supposed to be treated. Now, ACPO was actually developed before most of the computer forensics was stable. So it was developed by Scotland Yard, and they have certain principles that must be adhered to when it comes to digital evidence. Now, they have 4 principles. Principle number 1 is they say that no action taken by law enforcement agencies, persons employed by those agencies or their agents should change the data which may be subsequently be relied upon in court. Now, what this principle says that do not change evidence. Now, when you go to a place and you are going to acquire that evidence, the acquisition and subsequent analysis of data undertaken should make sure that data is preserved in the state in which it was found. So the forensic process or anything that you are doing to that data should not diminish the evidentiary value of that data. So this principle number 1 is no action should be taken. What it just means, do not change evidence. If you can prove to the court that the evidence that is before the court has not been in any way been changed, then that's okay. It can be admitted. Now, sometimes it might be that you are not, that evidence cannot be picked and taken to the lab. Then you have to collect that evidence from the live computer, which is live. For example, we have a situation where we have a server, and this server is used for other purposes within the corporation that you are investigating. In that case, you must collect the evidence from that live computer. And in that case, what happens that you must make sure that whatever you are doing has causes the least impact, and you must be somebody who is qualified to do so. Principle number 2 says that in circumstances where a person where a person finds it necessary to access original data, that person must be competent to do so and be able to give evidence explaining the relevance and implication of their action. Now, this principle what it implies that when you are dealing with data which is not stored locally, and you have to go to access that data or evidence remotely, then you must be somebody who is capable of doing that, somebody who is trained and knows what is doing, so that whatever you do, when you come to court and you are giving your expert testimony, you'll be able to explain to the court that this is what I did, and this is the repercussion of what I did, to show that, yes, even if the evidence could have changed, you can be able to explain what has changed. So that is the principle number 2, making sure that the person who is doing that is competent to retrieve that data and be able to explain what he has done when they are accessing that evidence. The other principle number 3 is an audit trail or other record of all processes applied to digital evidence should be created and preserved. An independent third party should be able to examine those processes and achieve the same result. Now, this is simple. What is this? What it says that it is essential to display some objectivity in the court of law, because the continuity, this will enable the court to see the integrity of the evidence. Now, what happens that when you are an investigator and you go to a place and get the evidence, now what you should do is that the process that you are using to collect that evidence should be actually there must be a trail, there must be a record, so that when you go to court, you'll be able to show how things were being done. This sometimes we call it the chain of custody. Now, sometimes I've gone to court sometimes, and I find that when I'm giving evidence and I talk about chain of custody, there's a time a magistrate was trying to downplay the importance of chain of custody. But it is very important, because if I go to court and I bring my evidence and the opposing side says that, no, we don't believe in what you've done, then I should be able to produce the original evidence. They should be able to do the same process, and they should be able to arrive at the same results. Now, the principle number 4 is about the person in charge of the investigation has the overall responsibility to ensuring that the law and this principle are adhered to. So that is ACPO principle. So we've talked about two guidelines and principle. That is the IOCE and the ACPO. The last one, which I wanted to talk about, is the scientific. Yes.
Mr. Dinga, remember we were to give you 45 minutes. Now I'm at 1946. Yes. But I just wanted to let you know that at this point we do not have any questions, because we are supposed to break at this point for the questions.
Yeah. Okay.
So we do not have any questions, so you can proceed. We will now break again after another half hour.
All right. Thank you so much. Now, the other organization I want to talk about is called the Scientific Working Group on Digital Evidence. Now, this is a US-based organization, but it is charged with the cross-disciplinary guidelines and standards for recovery, preservation, examination of digital evidence, including audio, imaging, and electronic devices. Now, what this organization does is that they have what we call the standards for exchange of digital evidence. This is what I talked about previously. What they're talking about is to enable any nation to be able to make use of evidence collected by other nations. Can we be able to reach this point? And this is what this SWGDE is trying to do. Now, they have a principle and some kind of SOP. Now, that's principle number 1, they say, is in order to ensure that digital evidence is collected, preserved, examined, and transferred in a manner that's safeguarding accuracy and reliability of the evidence, the law enforcement and forensic organization must establish and maintain an effective quality system. So that we know if the law enforcement or this organization maintain a good quality system, then we know that evidence that is coming from that organization can actually be used by our courts. Now, they need to establish this standard operating system, which are actually documented control, quality control guidelines that are supported, that must be supported by proper records and use broadly accepted procedures, equipment, and materials. But what is interesting in this organization is what they come up with, what we call, what they say call the standard and criteria. Now, I've just chosen some of the standard and criteria. I've not chosen all of them, but I've just chosen 2 which are of relevance to this training. Now, what is in standard and criteria 1.6 is that all activity relating to seizure, storage, examination, or transfer of digital evidence must be recorded in writing and be available for review and testimony. Remember ACPO principle number 3. So which means that this is something which is very important for digital evidence. I don't know for other evidence, but for digital evidence, if you bring anything to court and we cannot trace how this the collection, the acquisition was done, then automatically this evidence should not be admitted. Now, in general, documentation to support conclusion must be such that in the absence of the originator, another competent person could evaluate what was done, interpret the data, and arrive at the same conclusion as the originator. So it is important. This documentation is very important in digital evidence acquisition. You need to document each and everything that you are doing. The other standard and criteria is 1.7. Now, also it says it says that any action that has the potential to alter, damage, or destroy any aspect of original evidence must be performed by qualified persons in a forensically sound manner. Now, this is like principle number 2 of the ACPO. Now, because we say that whoever is touching the evidence, there must be somebody who is trained. There must be somebody who knows what he's doing. So to the extent that he'll be able to explain to the court what he has done with the evidence. Now, without this, we'll cast doubt on the evidence when it is brought to court. So that's why sometimes as expert witness, when I'm on the prosecution side and I've done my investigation, I'll make sure that I adhere to these principles so that when the other party asks anything, then they'll find that I already have what is needed in place. And if it is on the prosecution side, then they also need to make sure that I poke holes on the investigation that the other party has done, so that I can be able to get away with something. Now, let's look at the admissibility of digital evidence. Now, what are some of the challenges of inadmissibility? First of all, the electronic evidence, say that is fragile. It can be lost if it's not collected and preserved and guarded in a proper manner. So we find that in most cases, the guys who are doing investigation do not have this expertise to do this. And I've found, I've interacted with prosecutors who have brought evidence, digital evidence in court, but I'm finding that there's a big gap when it comes to investigation, because sometimes you find that it is the police who is doing the investigation, and this person is not, maybe is not qualified enough. He doesn't know how to handle the evidence. When they bring this evidence, there's a lot of loopholes that we find in the presentation of that evidence in the court of law. Maintaining the integrity of computer-generated evidence is still a challenge to many law enforcements, and proper procedures need to be followed to obtain evidence from a defendant computer in a manner that is legally acceptable or admissible in court. So law enforcement investigators also lack the essential technical training and expertise to effectively gather this evidence. So this is an area new, and we find quite a number of challenges when it comes to presenting this evidence in the court of law. Now, what are some of the factors or characteristics that somebody needs to observe before this evidence is admitted? First, we have to know evidence must be collected in compliance with the existing national legislation and best practices to ensure its admissibility in the court of law. So, because as I said, various jurisdictions have various rules of evidence. In Kenya, we have the Evidence Act. In the US, we have the federal rules of evidence. Each and every country has got a way of treating that digital evidence. So that is why when it is presented, you have to prove that it has been collected according to the existing national legislation and best practices. Now, one thing that is important is that evidence which is collected must have the legal authority. The process of collecting evidence is assumed to be legal process and appropriate rules of evidence in that particular locality. So, like in Kenya, if you are collecting digital, do we adhere to what is stipulated in the Evidence Act? Now, this is what we call we refer to fruit of poisonous tree doctrine in law. Now, the other thing is the authenticity. Authenticity is very, very important. It must show that the evidence is what it purports to be. An authentic evidence means that it is genuine and matches the claims about it. Then the evidence must be relevant, which means that when you bring an evidence, a digital evidence in court, then it must be able to establish a credible link between the perpetrator or and the target and the crime scene. So that has to come out very clear. Then there's the integrity of the evidence. Can we prove that this evidence has not been changed in any way, intentionally or unintentionally? Now, when you are collecting the evidence, this integrity aspect is always done using what we call hashing. Hashing is just taking information that is known to be good at that particular time, then passing that information through a mathematical function to produce another information called the fingerprint or message digest or hash value. Now this, don't worry, because this is always, when you do the acquisition of digital evidence, it is automatically done by the equipment or the hardware that you're using to acquire that evidence. But when you bring anything to court, you have to prove that, yes, this evidence is as good as the original and nothing has changed. The other thing is the reliability. Now, there must be nothing about the way in which the evidence was collected and subsequently handled that may cast doubt on authenticity and veracity. Now, when you are bringing the evidence in court, it must be reliable. Now, to ensure the reliability, you collected this evidence as investigator and you are bringing it to court. Now, the reliability will be shown by showing that you have the audit trail of how this acquisition was done, which has got the records of, I started the acquisition at this particular time. It was successful after this particular time. Anything that was being done during the coping process must accompany that evidence. That is how the reliability of evidence will be established. The other thing is the credibility. Now, credibility is a measure of witness and whether or not that witness is worthy of a belief. So a witness might be considered credible if they have reliable information about the event. Now, in digital evidence, to establish this credibility, the investigator who is presenting this evidence to the court must testify about his qualification. He must testify about the investigation that he employed and the tools and procedure that he used to collect and analyze this evidence, so that we know that this guy is actually has got the qualification to do this. Now, the qualification of digital forensics expert must be examined to establish their competency in handling and analyzing the evidence. So it is important for us, for the magistrate or the judge looking at the evidence, at the person presenting it, is this person actually qualified in terms of handling this evidence? Now, the other thing, the last one is what we call the validity of evidence. The validity, here we are looking at the way the evidence was collected. Was it collected in a valid manner? Whether there were scientific principles were used to preserve, acquire, and analyze digital evidence, and the standards were met to handle and examine that evidence, which means that here we are also looking at the standards and protocols of the forensic laboratory that was used to process this evidence. Were they reliable? Are they who are the guys who are working there? Are they competent? The equipment that they are using, are they up to date? The software that they're using, are they up to date? Because this can be challenged in court when you bring evidence and this POSA now, which particular forensic software are you using? Now, let's also look at the rules of evidence. When we're talking about the rules of evidence, we are saying that I've repeated that the digital evidence must be collected in compliance with the national legislation, and this legislation differ from jurisdiction to jurisdiction. So evidence must be that has to be presented in court must comply with that particular rules of evidence in that particular jurisdictions. So best rule evidence is established to prevent any alteration of the original evidence, either intentionally or unintentionally. Here, when we talk about original digital evidence, we are talking about you go somewhere, you collect the hard disk. Now, the hard disk has got all the data that you need. Now, so this is the physical item and the data object associated with such item at the time of acquisition. So that if that is the hard disk is what has got the evidence. So remember what you do is that you have to preserve that original evidence, because that is the best rule, the best evidence rule. Now, the duplicate evidence is now the accurate digital reproduction of the object contained in the physical original. So what you do when you have this hard disk, or you collected this hard disk, what you do, you don't do analysis on that particular original hard disk. What you do is you make what we call this bit by bit copy or bit stream copy of the original data, so that you work on the original or you work on the duplicate digital evidence, so that we adhere to principle number 3 of ACPO, that any person who says that now you also want to do the same thing that you did, they should be able to arrive at the same answer. Now, I say I talked about authenticity of digital evidence, and this is very important in court. Now, how do you then authenticate a digital evidence? Now, when we talk about computers generated content, we have 3 types of computer generated content. When you are content that is generated by one or more person, for example, you are doing an email, you are doing an instant message, word processing, such as Microsoft Word. That is content that a person is generating in the computer and storing in the computer. That is sometimes we call the stored content. Now, there's also content that is generated by the computer or digital device without user input. For example, if you are logging into the computer will keep the log on or the log files. There are certain things that you are doing in computer, and you do not have to do anything to generate that. The computer will automatically generate that data. That is what we call the content generated by the computer. Now, then there is the content generated by combination of both. That is the person and the computer. For example, if you're doing a spreadsheet, you input the data, the computer will interpret this, that do the calculation. Now, use the evidence that is user-generated content can be admitted if it is trustworthy and reliable, which means that it can be attributed to a person. Otherwise, it will be treated as hearsay. Now, device-generated content, that is the content that is automatically generated by the device itself, can only be admitted if it can be shown that at that particular time, the device was functioning properly, and the data was produced in a clear way, and can be shown that when the data was generated, security mechanism for that particular device was intact. So that is the device-generated content. You have to prove that. And I think this is this is taken care of in our evidence archives we are going to see. Now, the other thing is content that is generated by a combination of both computer and user input. Now, in this case, then you have to, the person seeking the admission should be able to address both the hearsay issues that is implicated by the user input, and then the authenticity issues that is raised by the computer processing mechanism. Now, for example, I just given an example. Here is a case where I was doing the authentication of an email before it was admitted as evidence. And you can see this is the email on the screen. The email that was being exchanged. Then from the other part of it, I'm now using the email technology to dissect that email to see whether that email came from this person, and this person cannot dispute that the email is not actually generated by him. And you can see this is a bit technical, but you can see you have the return path. I've put labels number 1. These are some of the things that we are looking at. We are looking at who generated this email? Was this email actually valid? Did it pass through the Yahoo because it was a Yahoo mail? Then I can be able to tell the court, yes, this mail actually passed through the Yahoo, and I have what we call the DKIM signature. I can also show the court that this email, if you go to Yahoo, and then number 3, I'll be able to retrieve this email. Then number 4, I can also tell that this email was composed using an iPad. And number 5, I can be able to show the court that the email was sent to so and so. So that is how an example of how email can be authenticated. Now, what are some of the authentication challenges that can be brought in court? One, the parties may challenge the authenticity of both computer-generated and computer-stored evidence by questioning the record, whether the record was manipulated, it was damaged, or when after it was created. Now, this is important because nowadays you've seen so many things like photograph, Photoshop. Things can be done by people, by hackers. Website can be created which mimics the real website. So that can be challenged in court, but you have to just come up with a proper reasons why you're challenging that. Now, parties can also question the authenticity of computer-generated records by challenging the reliability of computer program that generated the records. Was the computer working properly? Was that particular program which produced that evidence, was it okay? Or you can challenge the authenticity of computer stored records by questioning the identity of the author. Now, I've just shown you the email authentication there, and you could see that, yes, I can be able to attribute this email to the other party. Now, let's look at what we have in our jurisdiction. We have the Evidence Act in the section 65, subsection 8. Now, in this act, this act deals with the computer printouts, which says that a computer printout or statement in evidence must be accompanied by a certificate doing any of the following. The certificate will be identifying the document containing a printout or a statement and describing the manner in which it was produced. It's also giving the such particular of any device involved in the production of that document as may be appropriate for the purpose of showing that the document was produced, and dealing with any such matters as related to subsection 6. So section 65, subsection 8 deals with the certificate. And this is something that I've found many investigators bringing evidence, digital evidence court without a certificate. The other thing is the section 78A, which is dealing with the electronic messages. And it says that the weight attached to electronic messages, electronic and digital evidence is determined by the reliability on how it was generated, stored, or communicated, how it was preserved, the originator was identified, or any other relevant factor. So this, as we can see that in our jurisdiction, we have a proper way of identifying, presenting digital evidence in court. Now, in section 106B, we talk about the electronic records. Here, we are talking about the condition. There are conditions in order to satisfy the court. Now, it says that the electronic record was produced, fed into, or derived from the computer in ordinary course of business by a person having lawful control of that computer. Now, what is interesting here is talking about the computer must be properly functioning, and we to certify that the person who is lawfully in control of that computer. And then it's talking about the generation of a computer of a certificate signed by a person occupying the responsible position in relation to the operation of the relevant device, or manager of the relevant activities. So section 106B tells us that when you're bringing the evidence, digital evidence in court, it has to comply with the section 106B subsection 4. What is the function of the computer? It is identifying the electronic record containing that statement and describing the manner in which it was produced, giving such particulars of any device involved in the production of that electronic evidence. And also what is important here, the purporting to be signed by the person occupying the responsible position in relation to the operation of the computer. Now, this certificate, the law does not actually prescribe in the form of bringing this certificate. So this certificate can be in any form. It can be in form of a report, but it is signed, certified by the person who is giving the evidence, or it can be in form of affidavit, and it has to contain information that is required by the Act. Now, let's look at some of the case laws when we talk about digital evidence. The first one, which I've put here, is the Republic versus Mark Lloyd Stevenson, 2016. Now, here we are talking about authentication of evidence, and I've just shown you how in one case I authenticated the evidence, and here the High Court ruled that the email in question and the attached document were properly excluded from evidence by the magistrates court, as they were not properly authenticated. So you can see the importance of authenticating the email, because when it was brought to the magistrate court, it was rejected. It was not admitted. Then these people went to High Court, but the High Court stood with the ruling of the magistrate court. And what they say that it would have been appropriate for the expert to lay the foundation by authenticating email through email technological footprint. Exactly what I've just shown you that I did in one of the cases that I was working on. So authentication is required for any real evidence as opposed to testimonial evidence as being adduced in trial. The other interesting case was also the Rasanga versus Oduol in 2014. Now, the witness, the testimony was backed by a CD that was said to carry a video clips he had captured using his Nokia phone. It contained footage of an election clerk with a marked ballot paper preparing to stuff them into the ballot box. Now, the clip had been transferred from the phone to a disk without a certificate. The witness, being the owner of the phone handset, said nothing about its working condition, whether the phone was working in a working condition when this evidence was taken. So no evidence was given regarding the computer which was used to transfer the evidence from the CD, from the computer to the CD before it was brought to court. No evidence was shown to show that he was the owner and he owned and operated the device. So the condition of any device used in the process of creating it and a signature of the person who was in legal possession of the gadget. This was not provided. So what happened is that in the ruling by Justice Muchelule, he said that the person who had copied the clip from the phone to the computer had not created such a certificate to make the CD acceptable. So the reason why it was it was dismissed, that the reason for the particulars of the computers used in the production of the CD had to be given, and such particular would include the make and the serial number of the computers, so that when it becomes necessary, one can trace the devices for audit purposes. Remember the ACPO principle number 3. So you see the ruling was in favor of Rasanga, because the way this evidence was presented to the court, there was no certificate according to section 106B. Now, the witness testimony, now the other one is the Republic versus Wilfred Mechage and others. Now here is a different thing, because when it comes to presentation of the evidence. Now, the charge related to words allegedly uttered by the accused at a political rally on that date, the journalists had transferred the footage to a Mac computer at K24, edited it, and used it to run the news in that evening. Then K24 management authorized the footage and the news story to be released to the investigators, who ultimately produced it in court. Now, the electronic evidence footage that the prosecutors intended to rely on was not made by the journalist. Remember, the journalist is the one who did the shooting. But now, when it comes to the presentation, the journalist who had done that was not actually called for as a witness. So, since the maker of the record was not called as a witness, it was held that the footage was just a mere hearsay evidence. So the production failed to show the certificate signed by the person who has direct control of the device that was used to generate the evidence. The contents of the electronic recording had not been proved in accordance with the Evidence Act, and the video footage was therefore not admissible. So the evidence was crucial in its omission. The evidence was crucial, and its omission was fatal to the prosecution case. And I think these guys were acquitted. Now, the last case is that of Julius Macau, Malombe, and others in 2018. Here is also no certificate was produced showing the compliance and authentication of evidence required by as Section 106B of the Evidence Act. It was held that the certificate is required for the purposes of reliability, authentication, and integrity of evidence in terms of disclosing the source of the material, how the material was handled, and how the report was generated. So the certificate must uniquely identify the original electronic evidence and describe the manner of its creation, describe the particulars of the evidence that it created it, and certify the compliance with the condition of subsection 2 of the 106B. Yeah, that brings me to the end of my presentation, and I think I'll take the mantle back to you, Justice Kamau. Hello? Hello, Justice Kamau?
Thank you very, very much, Mr. Dinga. I think you have finished at the exact time because you're supposed to finish at 8:15. I can see now we are at 8. Can you hear me?
Yes, I can hear you.
Can you hear me?
Yes.
Can you hear me?
I can hear you, Justice Kamau. I can hear you.
All right.
Can hear you.
It looks like my internet. Okay, it appears that my internet is unstable. So I was saying, thank you very much for finishing on time. Very well. So thank you very much for finishing.
Kenneth, are you there? Yeah, Justice Kamau is back. You are muted, Justice Kamau.
All right, I'm back. Can you hear me now?
Yeah, I can hear you.
Okay, I'm sorry. This is a problem with the technology. Right. I was saying thank you very much.
Oh.
And now, can you hear me?
Yeah, I can hear you.
All right. Now, can you hear me still, Mr. Dinga?
Yes, I can hear you very well.
Right. Now, I'm saying thank you very much for concluding on time. And thank you very much. And to everybody else, thank you very much for the wonderful presentation. So I'm saying that today we have been able to learn about metadata. I've been seeing it in the KLR website. I did not know what that was. We have learned about several principles. We know that the lawyers were trained by Mr. Dinga, the same kind of training. So it is very important that the bench also is able to understand also when some of these challenges are brought to our courts. The bench will also have realized that today we talked a little bit about evidence and quite a number of things, section 106B, but that is also because there are also other investigators in the program and who are also involved in prosecution and other lawyers who might probably want to know a little bit more about the taking of evidence and the authenticity of the evidence. So I've looked at the chat and I cannot see any questions. So I think if the questions now, maybe the next time, maybe they'll come. But we had also given an email address for Kenise, Kenise at kcsfa.co.ke, in case maybe you have any questions that you'd like to ask. But we have been told that we are going to be given the recording, all the people who have been able to register in this program. For me, since there's no other question, I just want to really acknowledge the members of KMJA because those are the ones who I might be able to recognize. Like I said, the justices, Helen Omondi, Justice Kasango, I've seen you there, Justice Mumbi Gugi, Justice Cecilia Gidua, Justice Yoki Wamakau. I've seen several magistrates, Honorable Martha Nanzushi, I've seen Rosalind Aganyo, I've seen other people called Benning. All these are members who thought that it's important for them to come to this very important webinar. Because the next one will be on the 1st of October 2020. It's going to be a technical one, but it's important for us to be able to be on the same wavelength as the advocates and other investigators who are very well equipped in this area. So I hope everybody has been able to hear what I've said. I don't know, the internet was quite good. It also became a bit unstable. But at this point, I want to pass it over to Mr. Kenise Agira for him to give the closing remarks and maybe to give a vote of thanks for all the parties who have come. If I've not mentioned you as a member of KMJA, please notice because you did not put your honorable in front, so I do not know who you are. For all the other members and the other participants, you're also very honorable, and we are happy that you are here. And it's unfortunate that I've not been able to recognize everybody because of the time limit. But we appreciate you, we love you, and we hope that you're going to be there for the part 2. Mr. Kenise Agira, over to you, please.
Hi, everyone. Hello.
Hello, we can hear you.
Oh, thank you, Lawrence, for
Hello.
that informative. Yes, thank you for that informative presentation. And well, I must say it was packed. And again, people who had joined, I think they have had time to also listen to some of these concepts and all that. Well, what I can say is just at the start, we'll keep on making it better. I don't have much to say from now. We're going to welcome all those who have joined, tell them that, yeah, we are continuing to make it bigger and better. And I'll also express my apology. I'm made to understand so many people were trying to log in, but as it is, it was a bit controlled, so that has come some mishap here and there. But next time it will be better. I don't have much to say. Over to you, Judge.
Right. Thank you very much. Thank you very much for bringing it back to me. It's only now towards the end I'm seeing a few questions because I think there's one of them is excellent presentation. Please clarify the distinction between validity, reliability, and credibility. That is from Justice Helen Omondi. Honorable Paul Kibet-Ngetich is saying no mention or comment about cybercrime laws and Data Protection Act, but he says it's a wonderful presentation. For him, I think it is a comment that perhaps maybe in the next presentation, you need to probably mention that. But the question is, please clarify the distinction between validity, reliability, and credibility.
Ability and credibility.
And validity.
Now, when I talked about, these are some of the characteristics of a digital evidence when it is brought to court. Validity here, we are talking about was the evidence collected in a valid way. Here we are talking about the standards and the protocols that were for the collection of evidence. Was the standards followed, the collection standards followed when this evidence was being collected. Then we're also looking at the standards for digital laboratory where this evidence was examined. Do they conform to the agreed standards? Were the people who are examining this evidence, are they do they have what we call what do they have the competency? Do they have the qualification to do that? So it is just about the standards and the protocols of digital laboratory, as well as the standards that are used to collect the evidence. Are they internationally agreed standards? And are the laboratory which was used to analyze the evidence, do they have properly functioning equipment? Do they have up-to-date software? Do you have the competent people? Now, when it comes to reliability, here we talked about, let's go to credibility here. In the credibility here, we talked about the person who is doing the investigation. Now, if it is an investigator, is he qualified? The person needs to come to court and testify about their qualification. They need to come to court and testify about the investigation standards they employed, the tools and the procedures that they used to collect the evidence, and the way they preserve that evidence before it was brought to court, especially when we are talking about the volatile evidence. So that is what credibility. It talks about the investigation, the investigator, and the qualification. They have to testify. When it comes to reliability, now a reliable evidence is the one that we can be able to say that whatever the process that was used to collect this evidence is not casting doubt on its authenticity. Now, for you to prove it, you have to attach the process that you used to do the acquisition. For example, you have to show that when you are doing your disk imaging, what was by the time you started the process, how did it go? Is there an audit trail showing the records and which records the success and failure of any part of copying process, so that when the evidence is brought to court, then we know that the process is reliable, and we can establish from the evidence that from the record that it has been brought to court that yes, the process was reliable and the evidence can be relied upon. I don't know whether I answered that question.
Thank you very much. In case maybe the question has not been properly answered, then we will be able, Honorable Justice Helen Omondi is going to be able to send the question to us. So there was the issue of the mention of the Data Protection Act and the cybercrime laws. Maybe you can, in a line or two, Mr. Dinga, maybe you can tell us whether in the course of this part webinar series will be able to learn something or hear something about it.
Unfortunately, this course is not going to mention anything about data protection or cybercrime. That is another course that we can do on cybercrime and electronic evidence. But as for this, what I wanted to bring out is the part one is talking about the process, the investigation process. But the part two will now talk about the forensic, the digital forensics itself. The process of digital forensics itself. And then part three is supposed to talk about presenting that evidence in the court of law. But if we go to cybercrime, that will be totally a different topic. And I think it is not possible to merge it with this training. But we can do another training on cybercrime and electronic evidence, which will talk about the cybercrime, the effects of cybercrime, and the data and link it with the data protection if there's need to do that.
All right, thank you very much, Mr. Dinga. Please look at the flyer and see the expertise that he has, so that we encourage you to at least come for the second part 2, digital forensics process, which is going to be a little bit technical, and it's going to be on the 1st of October, 2020. We apologize to all those people who are not able to join in on time. I think there were some challenges with the link that had been given, but I think going forward in the next part 2 and part 3, we'll be able to give you a simpler way of joining the proceedings. And I think Mr. Kelly Zagira will be working in that area. So at this point, because we had promised you that we were going to keep you for between 7 to 8:30, and we started at 7:05. So I think 1.5 hours is ending in next 3 minutes. So we've managed to complete this in less than the 1.5 hours. And I know it's time for people to eat and to sleep. So at this point, let me say thank you very much for coming. We see you all on the 1st of October, 2020. So thank you very much. You can say bye as you leave. There's no problem. You can say bye and exit. Thank you very much.
Okay,
bye.
Bye-bye.
Good one. Good evening, everyone.
Thank you very much, everybody. Thank you.
Thank you.
Bye.